Hi, everyone. Welcome. Thank you for joining us. It is 6 o'clock our time and on the hour wherever you are. So we are going to get started. This is the third of our 4 student speech webinars that we're doing this month. This session is about teaching the Mahanoy versus BL case, and we are lucky enough to be joined by a special guest, Mr. Bob Korn-Revere. Today's session, in the first half of the session, we'll cover the case itself, and in the back half of the session, we'll talk more about teaching the case. And this session is being recorded. The recording will be available probably within the next 24 to 48 hours on Street Law's YouTube channel, and you can also probably find it being advertised on our social media as well. So here's our agenda for today's webinar. We'll start with just some basic welcome overview, introduction type stuff. And then Kathy is going to lead us through talking about the facts of the case. Then we're going to save a fair amount of time to have a question and answer session with Bob. And then we will talk about how to teach the case. So teaching some case study strategies using the case and using some of its precedents. And then we'll wrap things up and talk about where you can find all of these resources and any other next steps. To participate in today's webinar, there are a couple different ways that you can be involved. So the chat should be open for you to introduce yourself. If you want to introduce yourself right now, make sure that you click in the to drop down, you click to all panelists and attendees so that other people can see you and you can see if anyone maybe is from where you're from. But if you want to just in the chat box, introduce yourself and where you're coming from and what you teach, that will definitely be of interest to us and probably to other attendees. And we're also going to start collecting questions in the Q&A. So if you go down on Zoom to the black panel that's toward the bottom, you should see a little Q&A icon. And if you click on that, you can submit questions throughout the webinar. Those questions will show up to everyone, and those questions can be upvoted. So if you see a question that you really like, you can upvote it so that it goes to the top, and Kathy's going to be asking the questions that are toward the top of the list. We have 2 folks that will be presenting from Street Law today. I am Jen Wheeler. I work with the Teacher Professional Development team, and that is my email. And there's also Kathy Ruffing. Kathy is also on the Teacher Professional Development team, and I'll let Kathy do the rest of her introduction.
Yeah, that's my title. It's really long. I do the teacher PD stuff and the textbook stuff. I recently retired from 27 years of teaching in Fairfax County Public Schools. So shout out to my FCPS colleagues.
And we work for Street Law. If you don't know about Street Law has almost 50 years of experience developing programs and curricula that teach young people about the law and how to use it as a positive force in their lives. We do work in 5 areas: teacher professional development, legal community partnerships, legal life skills, global law and democracy programs, and curriculum and teaching materials. We have with us a very special guest, Mr. Bob Korn-Revere. Bob is a partner at Davis Wright Tremaine. He is a former FCC official, a Supreme Court advocate in lots of First Amendment cases. He is the outside counsel for the Stand Up for Speech initiative that litigates campus free speech cases, and the author of the amicus brief for the Tinkers in the Mahanoy versus BL case. So hopefully you have lots of questions for him about that brief. I'm going to show a quick video to give a little introduction, and then we'll let Bob also introduce himself. So let's...
When I first started working as a journalist, I was in high school and actually ended up in a situation where I was being paid for a weekly column for the local newspaper. And at the time I was making the princely sum of $3 a week. and I would write about things like, well, Kent State, the protests at Kent State during the Vietnam War. As I was working on the newspaper and going to school, I started looking at some media law issues, and so decided then, when I was planning to go on to law school, that I would look for ways to be involved in media and First Amendment issues. In this area, there are really two things. There are the people who are involved, but there are also the principles that are involved. And I think the thing that interests me about the people is that these are people who have put themselves on the line. They've dedicated their future to trying to vindicate some principle one way or the other. And from the standpoint of representing a company where the government is trying to limit its speech in some way, it's quite often very easy to see them just go along and look for the safer way to operate. I think it takes a courageous decision to decide to contest what the government wants. And so I admire and appreciate that kind of courage as well.
So I'm going to ask Bob to quickly take himself off mute and introduce himself.
Okay, I'm here.
Thanks. We'll hear a lot more from you later, so I guess save your breath for then.
Okay.
So a couple of objectives for our webinar series. This is for the entire series. So if you've joined us for all of our webinars, then hope you're getting all of these things. If you're just joining us for today, you're getting the Mahanoy specific objectives. But we want for teachers who attend these seminars to be able to use student-centered strategies to teach about both the Tinker case and the Mahanoy case, and also to support students in drawing connections between those cases. And a little bit later, we're going to talk about our student webinar that we're offering on the Mahanoy case. And so students who attend the webinar session will be able to learn about the case and its connections to the Tinker case. And with that, I'm going to turn it over to Kathy, who is going to talk about the facts of the case.
Great, thanks, Jen. So in the next slide, we'll see a picture of who we now know is Brandy Levy. We know that from interviews that she's given to the press, so she's not hiding her identity. Of course, cases that involve minors often use initials so that they're, to protect student privacy, which you as educators all know about. That is a picture of her. We're just going to refer to her as BL because that's the name of the case, and it seems like that's the way to go, but Brandy Levy is her name. And we'll talk more about all of materials that we have for you about this case on our SCOTUS in the Classroom site. Okay, so these are the facts that we know about this case. We know that BL was a sophomore. We know that she made the JV varsity team as a freshman and was really hoping to make the varsity cheerleading team as a sophomore. When the team roster came out, she was still on JV, and she was very disappointed in that. She had some other things going on in her life, apparently exams and some disappointment with a private softball team. And so when she was off campus one Saturday at the mall, so which seems a little cliche, but actually where she was, she Snapchatted the message that you see before you: F school, F softball, F cheer, F everything. But I do have to say that she did not use asterisks. So she fully wrote out the word. And that's important, and it might be important to your students, and I think it will be important, although we can ask Bob to weigh in on that when it goes to the Supreme Court, that the actual, full word was written out. She also made a second snap that was something to the effect of, a girl made the squad as a freshman, and I guess she was disappointed that she had been told that you had to spend a year on JV. So there was a second snap that said, here, I'll read so I don't misquote her: "Love how me," and the name of a student, which was redacted, "get told we need a year of JV before we make varsity, but that doesn't matter to anyone else." So she snapped, and I'm sure you're all familiar with Snapchat because you are in classrooms with students. But in case you've been living in a cave, Snapchat is a social media app that the message disappears in 24 hours. But I think everybody knows that screenshots can be taken, and Snapchat warns their users they can be taken. I think it's pretty much public knowledge. And that's exactly what happened in this case. A classmate took a screenshot of the snap and shared it with her mom, who happened to be a cheerleading coach. The cheerleading coaches got together and decided to suspend BL from the cheerleading team. They had rules in place, which BL was aware of, that said that that prohibited the use of vulgar language, criticism of the cheer squad, specifically on social media. And so she was suspended from the cheerleading team. And I'm going to open it up to Bob to see if there's any really important details that I've left out of my telling of this story.
No, I think that pretty well sums it up.
Okay, great. So we're going to go to precedent. So, or sorry, I lied. We're going to go to the First Amendment. So we all know the language of the First Amendment for sure, and your students will as well. They might pick up on the fact that the First Amendment is directed at Congress. So this is a great opportunity to talk about the 14th Amendment and incorporation doctrine, and how the 14th Amendment says that states also shall make no law abridging these things or preserve your privileges and immunities. But the language, certainly you'd want to start with the language of the First Amendment. And then of course it becomes, you know, social media is that speech. So we're going to talk about the precedents, and we're going to start with Tinker v. Des Moines. I'm going to give the briefest of overviews because I have a feeling that you're all really familiar with this case. And then we're going to ask Bob about the tests that come out of this case. So the briefest of overviews of the Tinker case is Mary Beth Tinker and her brother and another friend wore armbands to protest the Vietnam War in the mid-60s. They felt very, very strongly about this and other topics that dealt with the civil rights movement. And they wore them to school. The school found out that they had this plan to wear them, and preemptively made a rule against wearing armbands to schools, and suspension was the punishment. So they were suspended from school. The ACLU helped them take their case the whole way to the Supreme Court, and that's when the very famous line that probably almost everyone knows about not leaving your constitutional rights to freedom of speech or expression at the schoolhouse gate came. So they win their case. It is a victory for students, no doubt, but there's a little bit of a double edge to this decision. So I'm going to throw it over to Bob to talk a little bit about the substantial disruption or Tinker test. And in all the other cases, we're going to talk about how this case applies to Mahanoy v. BL, but this time we're not, because later on we have an activity that we're going to ask you to participate in that, that you might have your students participate in as well. So we're going to hold off on specifically how Tinker v. Des Moines applies to this case, but we are going to ask Bob to tell us about the Tinker test because it's going to be really important in this case that we're talking about today.
Okay, well, everybody, it's fair to say that the Tinker decision is the most important First Amendment affirmation of student First Amendment rights that the Supreme Court came down with, and it's important both because it was the first affirmation of those rights for public school students, but also because it, up to this point, has been the most speech protective of those decisions. Basically, it affirms that students do have First Amendment rights, even though they're attending public schools, that, as Kathy said, that neither students nor teachers shed their First Amendment rights at the schoolhouse gate, and that schools can't become enclaves of totalitarianism. Now, it does recognize that there has to be an accommodation, something of a balancing of those interests, because schools have to be able to do the business that they're set up for, and that's both educating students and maintaining some discipline and order. But at the same time, this doesn't give the schools complete license to regulate speech altogether. And so essentially it has to be speech that is substantially disruptive or invades the rights of others. Those are really the two elements. And it also can't be just a fear or unfounded apprehension that the speech may be substantially disruptive. There has to be some evidence to support that, even though school administrators will be given some latitude in that regard. Now, in the facts of the Tinker case, where John and Mary Beth Tinker and a few friends decided they were going to wear black armbands to protest the war in Vietnam, there was really no evidence of any kind of disruption. And it was essentially the school board simply got wind of the fact that students were planning to do this, held an emergency meeting, and passed a special rule to prohibit the wearing of black armbands. The question that has sort of nagged courts ever since has been whether or not that speech extends to expression that is conducted off campus. And that's why social media, as in the BL case, has presented such a conundrum for the courts.
Great, thanks. Okay, so there are two other precedents that we're going to talk about, which we think are going to be really important in this case. Bethel v. Fraser, or Bethel School District v. Fraser in the mid-'80s, right around when I graduated from high school. This is a picture of Matthew Fraser, and he gave a speech in front of the student body in support of a classmate who was running for student council. And he didn't use any profane words like BL did, but he did make lots of sexual innuendos to the point where it caused a little bit of a disruption in the audience. And so he was disciplined in his school. And so the question becomes, in this case, can lewd speech be restricted by the school? And I'm gonna leave it up to Bob to tell us a little bit about this decision, and he can this time talk about how this precedent might be applied in the case of Mahanoy VBL.
Right. I mean, this is sort of an offshoot from the cases that came up under Tinker, because Tinker involved student-initiated speech, where you have students who decided they were going to deliver their own message about a political topic. It was not sponsored by the school. In Bethel School District versus Fraser, you had a student who was giving a speech at a school assembly, and it was a sort of a campaign speech for a fellow student, which, as Kathy mentioned, was laced with double entendre, and that the student had been warned against giving. And so the rule has emerged in those post-Tinker cases that schools have even more latitude to regulate student speech when it's part of a school-sponsored event or is part of a school activity which has the imprimatur of the school. And so that was the category that Bethel School District fell into.
And how do you think both sides might use this in the BL case? Or do you think that it helps one side substantially more than the other side?
Well, it's interesting in that you're
let me just say, we're going to use the terms later, analogous and distinguished. So how is this case similar, and how is this case different from the case at hand? Okay.
Well, it's similar in the sense that you're talking about the school's ability to regulate off-color language. And so the Snapchat posts where you have expletives and so on and gestures that were of the kind that, had they been in Fraser's speech, the question would be clear that those are the kinds of things that schools can regulate just to maintain order and discipline in the usual school functions. What makes this different is the fact that you're not talking about a school assembly or a school-sponsored event. Yes, BL was a member of the cheerleading squad, but she wasn't doing this as a cheerleader. at a school event or at a game or anything like that. She simply sent posted the photo and her message on Snapchat. It was sent to roughly 250 other students, but again, would have disappeared entirely in a few hours had it not been captured in a screenshot and then another cheerleader taking it to her mother, who's a coach. So it's different in that it doesn't fall into that category of school-sponsored or school-sanctioned activities that are subject to special regulation. You can argue that, you know, because she's a cheerleader, there's that connection to the school, and in that sense, there's a sense of school sponsorship, but it's really different because she's really just using her own Snapchat activity and social media activity to deliver her own expression of angst. Let's put it that way.
Great, thank you. Okay, the next case, I know a lot of teachers enjoy teaching, but might be to you, Morse v. Frederick. So this case is about Joseph Frederick, and he was a student in Alaska, and the torch was going to be run down a road very close to the high school that he attended. And so the administration thought, well, this would be a great activity, take our students out and they can see the torch run by. So Joseph didn't go to school that day. He stayed home, maybe making this beautiful sign, Bong Hits for Jesus. You might have seen it at the museum if you were lucky enough to see it before it closed. It is basically that kind of paper that, you know, big poster paper, and then it's duct tape. So it looks maybe like it's painted, but those are actually pieces of duct tape. And he said he came up with the saying Bong Hits for Jesus. He had seen it on a snowboard, I think, and he thought it's just like a nonsense kind of thing that's going to get me on TV. So by his own admission, his motive behind this was to get on TV because he knew there would be some media as the Olympic torch passes by. So he doesn't go to school in the morning, but he does go join his classmates and unfurls this banner. The school administration has a policy against speech that promotes drug use, and he is suspended and disciplined. And he and his father bring a suit against the school. So this case is actually also about, you know, can the school be held responsible for the disciplinary action of the principal, which is why there's not a school named in this, but the principal is Morse. Okay, so we'll let Bob tell us how this case turned out. Jen will pop that up, and how this case is similar or analogous to Mahanoy and different or distinguished.
Yeah, this is a really fascinating case because it is the one school speech decision that has come out of the Roberts Court and caused a lot of discussion back and forth about whether or not the Roberts Court will be as protective of student speech as it has been of speech in other areas. And, you know, frankly, it's made people a little bit pessimistic about that. It is one of those, and by the way, I should say, student speech cases that reach the Supreme Court are few and far between. And because of that, people tend to read a lot into each one of them and to see how it's going to affect, you know, future cases, just as Morse versus Frederick plays in here. This is an example of two things, well, many things, but I'll mention two of them. One is it's an example of how student speech cases quite often are not taken quite as seriously when the speech isn't considered to be serious. And so here you have a nonsense phrase, Bong Hits for Jesus, where when Frederick was asked in deposition, well, what were you trying to say? What was your message? And his response was something like, I don't know, thought it was funny. And so, you know, the court really didn't have a peg to hang on, like it in the case of Mary Beth Tinker, where you've got pacifist students wanting to mourn the deaths of people on both sides of the Vietnam conflict and wear black armbands. You know, there's a seriousness of purpose to that you don't see in this. And so the speech interests are taken really less seriously. The second thing about this is that it was a bit of a stretch for the court to reach the conclusion that this was really a school-sponsored event. As Kathy mentioned, this was during the presentation of the Olympic torch, the running of the Olympic torch through town. The students weren't at an organized event. They were simply led out of school so they could see the passing of the Olympic torch. And so that didn't deter the court from saying, well, we'll call that a school-sponsored event, and extended the court's or the school's jurisdiction over what they were doing by virtue of that school sponsorship. Also, kind of as a side note, it's interesting, as I recall, and it's been a while since I've looked at this, but I seem to remember that when the school principal approached the student and said, you can't do that here. And he said something, I'm going to suspend you for 10 days. He said, I have a First Amendment right to do this. And she responded, okay, 20 days. So it shows you what being a student lawyer will get you. The effect on this case, again, is going to be kind of interesting. Again, like Morse versus Frederick, the student speech in this case is considered to be more trivial. There's not a serious message here or a political statement. And so, you know, sometimes it's a little bit harder for courts to find the principle involved. But that being said, like all First Amendment cases, all important First Amendment cases, it's not so much about the speech as it is the power, right? Do we give government officials the kind of power to restrict speech, serious or not serious? And that extension of power is what is serious. And so the question here is whether or not the court will look at the asserted power of the school district to reach not just students in school, but any student who communicates anything. And it's available to the school by virtue of the internet.
Great, thank you. Okay, so we're gonna launch into Q&A here. We have a lot of questions already in the Q&A, and as we usually see that once we get rolling, people will have questions that come up. Don't forget, if you're about to submit a question, that you look to see if someone has submitted a question that's similar to yours, because it will rise to the top faster if you upvote a question. So look to see if someone has a very similar question and upvote that question. If not, please submit your question. We'd love to see it. So the one that's risen to the top of the list is, how important or impactful do you think the signed code of conduct is in this case? So I'm not sure I've read that it was actually a piece of paper contract that she signed, but she, maybe it was, and maybe you know that detail, but for sure she knew, she was aware that she was agreeing to these rules about specific language on social media and criticizing the cheerleading team on social media. So how important do you think that's going to play a role? And it doesn't play a role. I'm going to add to this question a little bit. I hope that John doesn't mind. Does it play a role in your amicus brief that you're writing for the Tinkers?
I'm sorry, I was reading some of the questions here. I think for purposes of the case currently before the court, the specific content of the policy isn't quite as important, because the question that it accepted review on was whether or not the school's authority could extend beyond the school and to off-campus speech as well. And that's what the court is going to focus on. I think as a First Amendment matter, as a general proposition, the policy is significant. Some would argue that it's significant in that the student who joined the cheerleading squad signed away their rights by agreeing to a policy. I don't think it's really quite that simple, because what you have here is a policy that basically says, be respectful, don't use foul language, don't use obscene gestures, don't express negative thoughts about the team. it is so hopelessly broad and vague that it's not possible to use a standard like that to regulate speech, even student speech. It's kind of like a school civility code. The kinds of codes that have been struck down by courts across the country, basically saying, be civil, respect each other, all nice sentiments, but not the sorts of things that you can use to regulate speech in a system governed by the First Amendment.
Great, thank you. Okay, the other one that has a lot of votes is our school has banned Black Lives Matter and Blue Lives Matter masks, claiming it would cause substantial disruption. How do you think that would be decided?
Well, it's a really interesting and very timely question. It reflects the kinds of issues that have come up in various courts around the country as well, not so much in the student speech context, but it came up, for example, in the Transit Authority in Pittsburgh, where the question was whether or not transit workers could wear Black Lives Matter face masks, or some would wear others as well. In the school context, it's going to come down to the specific facts of any situation, right? If a school can demonstrate that there is a specific threat of disruption, then perhaps they could adopt some kind of policy. But again, these things are so very fact specific. But what schools would not be able to do is ban one but permit the other, right? It doesn't get to take sides. So if there is a hint of viewpoint discrimination between the kinds of messages allowed and those not allowed, then that would present a particular First Amendment problem. And there's an element of that in the Tinker case, where the court said that it's relevant to their decision, the fact that the school only focused on the anti-Vietnam War protests and banned armbands, but they permitted other kinds of political symbols, including like the Iron Cross, which is called as a symbol of Nazism, and things like that, that other students would wear during that period in our history.
Okay, so I have a follow-up question. So you mentioned that schools would have to show some proof that there is a real danger of a substantial disruption. So what kind of proof can a school use to support that claim that there is a substantial risk of disruption?
Well, typically what schools would do is point to the evidence that they had gathered at the time of whatever the incident is. In some cases, they'll say, well, we have this kind of speech, and here were all the various reactions that, and there were, people got in fights and different kinds of things like that. Or perhaps they could show social media traffic that would indicate, a lot of unrest, arguments. Those are the kinds of things they would point to. But that's why I mentioned that it is so very fact specific, because of the admonition in the Tinker decision that it can't be simply an undifferentiated fear or apprehension that there's going to be some kind of disturbance. It needs to be backed by some kind of evidence.
Great. Okay, next question. Would it be different if it were a school suspension rather than a club sports suspension? And then it says, I can't remember the case, but is there a difference for extracurriculars so they can regulate behavior more? So they might be thinking maybe about like Potawatomi v. Earls or something like that. That was a distinction between extracurricular activities and
right, but those are
athletic activities with Vernoni v. Acton. Right.
It might be a factor, but I don't think it's going to be a decisive factor. I mean, it's one element that has been argued in the case, that there are special rules for extracurricular activities. But I think anytime you're conditioning a school activity or school attendance on the relinquishment of constitutional rights, you're going to have a constitutional issue.
Okay. Jen just wrote me a note and I can't find what she's talking about. Jen, will you put it in chat for me?
Yeah, I mean, I could just ask the question.
Yeah. Okay, will you please? There was a follow-up question that I had.
So there's a follow-up question on that question. that says, I'm the school activities director, and we have our kids sign a code of conduct. Where does that where does our co-curricular program fit into this universe of free speech?
Thanks, Jen.
Could you repeat that? I'm sorry.
Yeah. So this person is the school activities director, and they have the kids sign a code of conduct. Where would the co-curricular program fit into this student speech universe?
I think this is very much like the earlier question about whether there's a different standard for schools generally as opposed to participation in an extracurricular activity. You know, there will be some people who will argue that participation in an activity is merely a privilege and school attendance is closer to being a right. I'm not so sure that that would stand up on close examination. You know, there can be significant consequences or social consequences or otherwise if students are, say, arbitrarily denied the ability to participate in extracurricular activities. And so, again, I think, again, the court may well touch on this because this was a cheerleading activity in this case. But I don't think it's going to be decisive.
Great. So the next question is, to what extent does the fact that it was other students that initially expressed concern rather than adults only, how might that impact the BL case? And there's a follow-up, would that be enough to be considered a potential disruption since many in the school's student body saw it? So I think they're asking, you know, can you use that as evidence of a disruption, the fact that it was brought to the attention of the cheerleading staff by other students?
Yeah, I have found the showing of substantial disruption in this case to be particularly underwhelming. You know, it's hard to say that you've got evidence of a substantial disruption when the evidence of that is a couple of high school cheerleaders got the vapors. You know, it's, and even if they took it to mom, the coach, and said, look at this, again, this is more in the, to me, falls more under the category of school gossip than it does school unrest or actual disruption. The fact that stuff gets talked about, you know, again, think about applying that level of disruption to a situation like Tinker, where you did have, you know, a math teacher complained that students were distracted because students wore armbands. You have, well, actually, you had threats of violence to the Tinkers. I mean, red paint was thrown on their house. Mary Beth Tinker got a harassing phone call and a death threat from all of this. So, you know, that, and at that time in our history, when people were really divided over Vietnam, that strikes me as more of a basis for arguing substantial disruption than the fact that, you know, a cheerleader comes to school and is upset that she saw something on Snapchat.
Okay, the next question, I don't know if you know the answer to or not, but it raised some issues. The next question was the snap in question posted on her story, or was it sent privately to her friends and peers? So I've read all of the briefs that were filed so far, and I've just seen it said that it was sent to her friends. I didn't see anything explicitly talking about this. But it does bring up something that I wanted to raise to the teachers, and that is that BL's brief was just posted today and is actually still not publicly available as far as I know. And so we will read her brief and may slightly revise our materials based on any important facts that come out in her brief. So we read the petition for certiorari, and we read some lower court things from them. And so we think we have the story straight, but when that is publicly available, we will maybe need to make some changes, and it might be something like that. It might be, you know, a fact-based thing like that. So I'm not sure, are you aware of that? the answer to that question, Bob?
I don't know the answer to that question. I just know from reading the case that it went to about 250 friends, and that apparently one of them made a screenshot and took that to school.
Okay, so a question, actually leapfrog that one while I was talking. That's the beauty of upvoting. How much will the court consider the ramifications of their ruling one way or the other in the Mahanoy v. BL case? I have students who are curious about what this case means for their speech rights when they are considering venting on social media their frustrations against the school district administration.
Well, I mean, that's the whole ballgame. That's the whole case is about how far the school's authority extends. And, you know, in this case, it really does go to the heart of the question that Stephanie raised about what this means for student activity on social media. There have been other cases, which is why this got to the Supreme Court. There have been other circuits that have decided that off-campus speech can be regulated, but those have almost all involved cases where you had the speech that went to the second prong of the Tinker test, where there is an invasion of the rights of others or an infringement of someone's privacy. They involve things like direct harassment of individuals or threats of violence, or those kinds of things that are not protected speech anyway. This involves something where you're not talking about harassment or bullying or a death threat. You're talking about a student venting on social media. And so this goes to the substantial disruption prong of the Tinker test and not the invasion of others' rights. And so the question is, when students are speaking off campus, can what they say be regulated by the school because it's disruptive? And what it means is that if, depending on how the court answers that question, is whether or not the students' rights, not whether they shed their rights at the schoolhouse gate, but whether they shed their rights simply because they're students, right? Is the price of attending public school giving up essentially your ability to speak on social media? Because as the petitioner presents the case here, they say that anything that involves other students or is directed to other students is something that involves the school, which means that anything you say on social media, if that test is adopted, that you actually tell another student can be considered speech directed to the school environment because it's foreseeable that it could reach the school. Someone could print it out and take it to their mom, the coach, right? And so this means that all social media speech is now under the supervision of the public school. Now, the only question then is it disruptive enough? And that's the other part that makes this case so important, because here, depending on how that question is answered, it means simply someone getting upset at an expression posted on social media can be enough. So it really is a very significant case in that respect. And if students are worried about venting on social media, either about the school or its policies or about a teacher or about the principal, they should worry.
So the next question is, in the context of content-specific regulation, what about Confederate flags? Would the school need to restrict all flags? And 2 weeks ago, we talked a little bit, I don't know if Matthew was here for that one or not, but we talked a little bit about the Fourth Circuit South Carolina case, Hardwick v. Haywood, the one that said that, Confederate flags can cause a substantial disruption and were allowed to be banned.
Right, and I'm not familiar with that specific case, but I've read other cases that do talk about symbols like the Confederate flag that have been considered to be disruptive, which is why, as I mentioned earlier, these cases are always very context specific. It can depend on the particular message. It can depend on the particular time in history that we're in and whether or not that is controversial. that gets us to things like Black Lives Matter, which at a certain time can be considered controversial and another time not. In the wake of Charlottesville, certain kinds of expression is going to be considered more sensitive and potentially disruptive than other speech. And certainly that's true of the Confederate flag, as during and since Charlottesville, the whole argument over Confederate symbolism, statues or flags or whatever, have raised the question of whether or not that is too disruptive. And so you really do have to look at both the particular kind of speech involved and what's going on in the context of that time and in that school. And you can get a different answer based on different times. It's also come up with respect to religious speech, right? Where you have speech either condemning or condoning homosexuality. And the question is whether or not you can prevent students from wearing a t-shirt that, in one case, it was saying, let's see, be happy, not gay, right? In that case, the t-shirt was permitted. In another case, a biblical phrase condemning homosexuality was not. So again, it really does depend on the context.
So doesn't that come into conflict though with the whole concept of content neutral?
It can.
That policies have to be content neutral.
Yeah, it absolutely can. Well, more viewpoint neutral than content neutral, but yeah. And that came up in a case in the Ninth Circuit about 5 or 6 years ago, the Dariano case, where you had a school celebration for Cinco de Mayo, and a group of students wanted to protest that by wearing American flag t-shirts on Cinco de Mayo. And the school district prevailed in that case, saying that wearing the American flag t-shirts in response to Cinco de Mayo was potentially disruptive. And so it can be a really difficult line to walk. And I think it's one of the reasons why the ability to restrict speech has to be interpreted very narrowly. And that's one of the things that comes up in the BL case. As presented by the petitioners in the case, by the school district, they're saying that Tinker was not a narrow exception to the general protection for free speech rights, that schools are given a lot of authority to regulate speech under Tinker. Whereas if you read Tinker, it basically says that freedom of speech is the rule and the ability to regulate it and restrict it is a narrow exception. And here are the categories where that's permissible. This case squarely presents those competing interpretations to the court, and we'll see in what it does, whether it wants to maintain Tinker as a narrow exception to free speech or as a broad exception.
Okay, the next question, did the student who screenshot the snap and shared it also get suspended, and could she have been? I didn't read anything about a suspension, so I'm guessing that means no, because I think someone would have brought that up had she. But if you have different information, please share it. And could she have been disciplined?
I don't know one way or the other, but I highly doubt that the student who brought the damning evidence to the authorities was sanctioned, probably given a medal.
Yeah, I didn't read anything either. Okay. Now that more school classes and activities are online, how has the definition of on-campus changed? That's
such a good question and such an impossible to answer question. I was at work all day and I never left the house. So, you know, what does that mean? It's something that the Third Circuit, in its opinion in this case, gave a lot of thought to, saying that, you know, what does it mean for us all living in the online world today? And it does really blur the lines. And the way it came down, in the decision was to say that, are we saying that the schoolhouse gate, where school authorities begin to have their jurisdiction to regulate speech, does that now extend to the public square, since the public square now includes the World Wide Web and the internet and social media? And it said it was not prepared to say that the school's authority extends that far, because then Tinker would no longer be a narrow exception to the protections for free speech. And it really is a difficult question to answer as a blanket rule, right? Because, you know, if by virtue of going to a public school, the school authorities have the ability to regulate everything that you say online that might be repeated at school, then there is no limit to that authority. You know, I think it makes a lot more sense to try and look at the nature of the speech. If the speech is some kind of directed harassment or an attack on somebody, which can affect their rights and would not be protected, then yeah, the school would have more authority in that circumstance. But in those circumstances, the school's authority is almost redundant, because in many cases, that speech is addressed by other laws, and both civil and criminal laws, including defamation, specific harassment, threats, and so on. But if you interpret this to cover all speech, then basically now the school authorities, if this interpretation prevails, would have the ability to regulate all speech on all social media all the time, if it could reach the school.
One question I read posited in one of the briefs, which I assumed was Mahanoy, but I can't put my finger on it at the moment, so I don't want to swear that, was what about speech where the speaker is one step outside the schoolhouse gate, but speaking loudly enough that everyone inside the schoolhouse gate can hear? Obviously a metaphor for social media, right?
That's a hypothetical that comes up constantly in the petitioner's brief in this case. They mentioned it at least 3 times of that sort of thing. What if you're just one step away? And this is, the Third Circuit already addressed that in its opinion, saying that some speech, if it's so associated and so connected to the school that, you know, it affects the school, you don't consider that off campus. And it addresses the situation of someone standing across the street with a loudspeaker. And in fact, the Supreme Court looked at that kind of issue in the 70s, in the Granted case, when it was looking at 2 Chicago ordinances that regulated activity outside the schools, one of which was an anti-noise ordinance, where the noise from the speaker across the street affected the school. And it said that that rule was constitutional, because that really is not off-campus speech, since the speech is intruding on the school. There was another part of the ordinance that was content-based, that said if it's non-labor picketing, then it's permissible. And the court struck that down, saying that you can't pick and choose among who gets to speak in that circumstance. So, yeah, I mean, I recognize that in the petitioner's brief, it makes for a very colorful hypothetical to say, well, if you're just one step away, you can't just draw that as the line. And the Third Circuit's decision considered that and provided, I thought, a fairly nuanced answer to it.
Okay, so last week or 2 weeks ago, Mary Beth was talking about a dissent from Justice Clarence Thomas, where he said he'd like to see Tinker overruled. So this question is, do you see that as a possibility, or do you see this case being remanded to the Third Circuit and then being told to decide actually using the Tinker standard like most of the amicus briefs seem to want?
I don't see a possibility that the court's going to overrule Tinker as a matter of pure doctrine. And for no other reason, because Chief Justice Roberts is very loath to do such a thing, and I think most of the justices are. And no one is really asking for Tinker to be overturned, notwithstanding anything that Justice Thomas might say. I think the bigger danger is that if the school's authority is extended without without boundaries, that Tinker would effectively be overruled. Because if you think about it, if Mary Beth Tinker were a high school student today, or as in the case at the time, a junior high school student, she wouldn't be putting a black, or she might be putting a black armband on, but she would first be putting on social media the fact that she was going to wear a black armband and have her picture with a black armband on social media. The meeting that led to the case started out in the home of a family friend of the Tinkers, Christopher Eckert, where they talked about their plan to wear black armbands. And it was that discussion in someone's home that got to the school. Somehow the school board got wind of it and passed their special rule against having black armbands. And so those are exactly the kinds of speech that would be roped into the school's jurisdiction under this case if the Supreme Court accepts the argument being made by petitioners that off-campus speech in the home, because it involves speech between students and speech about student affairs, and it reaches the school, it's foreseeable it could reach the school because they were talking about maybe wearing armbands. That would be now covered by the ability of the school to regulate speech. And if the argument could be made that that would be substantially disruptive, then that would be fair game. So the precedent in Tinker, the case itself, is not going to be overruled, I predict. But if the court, depending on how the court answers this question, Tinker would effectively be overruled because, you know, what Mary Beth Tinker did in 1965, had it been done in 2021, would then be subject to the regulation of the school.
Okay, this is probably going to have to be our last question because we only have a few minutes left with you. So is there a litmus test or a standard that helps students understand what substantial disruption means? Is it a student walkout? Is it a fight?
Well, I think all of the above. I think a student walkout would definitely be substantially disruptive. I mean, anything that prevents the school from performing its function, I think you would say is a substantial disruption. And a fight definitely falls into that category. Now, it would depend on how widespread it is. In the Tinker case, for example, one of the things that Justice Black pointed to in his dissent was the idea that there had been grumbling among some students, and he pointed to the fact that a football player was told to, evidently told some of the students who had been grousing that they should leave the demonstrators alone, and that was taken as substantially disruptive. As I had mentioned, this is very fact specific, and cases have been all over the board on this kind of thing. But as far as a litmus test goes, I think you can say that if, you know, it's something that takes students out of class, or if there is sufficient evidence of fighting, then I think those probably would qualify.
Okay, and I think I fibbed because I'm going to ask one more question because I think you can probably answer this question in one word, and that is, could you please explain how students' rights are different in private schools? Would Tinker have been decided differently if they attended a private school?
Well, the First Amendment does not apply to private schools. The First Amendment only is a restriction on state action, and so that's really all that we're talking about here.
Great. Well, Bob, thank you so much for joining us tonight, and appreciate so much your really thoughtful yet understandable to those of us who aren't First Amendment, award-winning First Amendment litigators. So we really appreciate your help. And Bob will be back with us next week for your students. So please invite your students.
Nice talking with you all, and good luck with your sessions.
Thank you, Bob.
Bye.
Thanks, Bob. All right, so now that we have reached the second half of the webinar, we're going to go until 8 o'clock Eastern time. We're going to talk a bit about different strategies you could use to teach this case. And we've got some interactive strategies, so hopefully that can also make things interesting. So Street Law likes to kind of employ a method with different Supreme Court cases that we like to call case study strategies. And case study strategies use Street Law's case summaries in a bunch of different ways. So there are hundreds of Supreme Court case summaries in Street Law's free resource library that have all of the elements that you see on the screen. So the case summaries have the facts, the issue, the precedents, the arguments, the decision, as long as there is a decision. Obviously in Mahanoy, there's not a decision, but as soon as it's released, usually within, a couple hours, I feel like we have the decision up and uploaded into the resource library. And we have started making a few adaptations to this list, but generally speaking, this is what you're going to find when you find a case summary. You're also going to find in the free resources that case summaries are in Word documents because we want you to be able to manipulate them in order to be able to create different activities. So we have 7 different activities that, that we suggest trying to use in order to teach about Supreme Court cases. These kind of go up the scale and level of rigor. So starting with the anatomy of a case, that case study strategy, it's a pretty basic one where in a case summary, you delete the subheadings. And where it says facts, where it says issue, et cetera. And you'd ask students to try to figure out what each section is. With some students who are really with it, you can probably only do this once before they get it. But it's a good way to maybe introduce case summaries. Then there's choosing unmarked opinions. Of course, that one only works if there are opinions, which nearly all of our cases do, just not these SCOTUS in the classroom cases. But asking students after they've read through everything but the decision to take a look at an unlabeled majority opinion and an unlabeled dissent and try to figure out which one the court actually decided. But you can also ask the question, and we like to ask this question a lot, which one they should have decided as well, because sometimes those answers are different. We're going to do a variation on the classifying arguments activity. This is probably one of our favorites, but this one takes the arguments and removes the labels and mixes them up and asks students to figure out which arguments fit with which side of the case. Judicial opinion writing says, get rid of that decision and ask students to be the justices and write the decision. Student law firms asks students to brainstorm the arguments themselves. So in that case, you'd get rid of all or maybe most of the arguments. Applying precedents, which we will do later, is after examining a case, students analyze how the case and a precedent case are analogous or similar and distinguished or different, and then weigh those similarities or differences to make an overall judgment about whether the precedent case is analogous or distinguished. Did I get that right, Kathy? Okay. And then finally, one of our most favorites as well is the moot court and the mini moot, where you actually simulate a Supreme Court hearing and kind of make the whole big shebang happen. So we are going to do our first activity using a tool called Poll Everywhere. And Kathy just dropped a link in the chat where you can copy and paste that into a web browser, or you can type it into your phone's web browser also, but that will allow you to participate in our activity that we're going to do here in a moment. So I need to do this. And this activity, we're going to give you a little bit of time with. I said that we're going to do a variation on the classifying arguments, and the way that the variation for this works is that we've already told you which arguments are on which side. We're telling you that these are the arguments for the Mahanoy case, but we want you to read through the arguments and rank them in terms of which arguments are most compelling toward the top and which arguments are least compelling toward the bottom. And so when you do this in Poll Everywhere, if you click on one of these arguments, you'll see a little up arrow or down arrow, and you'll be able to kind of move them around. And then eventually you can hit submit once you feel satisfied with the rankings that you've given it. So we'll give you some time to take a look at those arguments and then rank them according to how compelling they are. All right, so here are some of the answers that have started to come in, and you'll see these move around as people hit submit. And if anyone wants to send us any of their reasoning for why you said what you said, we're happy to, I don't know that the chat, if you guys can see each other's chats, but we can see what you send to us. So if you have any reasoning that you'd like to send out for why you're ranking the way you are, we'd love to share that. Let's do maybe 30 more seconds. All right, we've been having a few issues with chat tonight. I see that Ryan put that it was just disabled. So hopefully we'll be able to figure that out and get it back up and running. So it looks like the precedent argument, the Tinker argument, is one of the, it is the most compelling argument, which is a great segue into what we're going to do later. Also interesting, the schools need to be able to prevent bullying, kind of that interference of two rights kind of clashing against one another. So let's go to the arguments for the for BL. I'm going to disable this one. And here are the 5 arguments for BL. This should be active now. So as long as you didn't close out the Poll Everywhere, you should see this pop up. If you did close out Poll Everywhere, you can just type pollev.com/streetlaw-inc431 back into your web browser. Take a look at these 5 arguments and rank these 5 arguments. And as you're ranking, I'll talk a little bit about Poll Everywhere because people always have questions about Poll Everywhere. So what you're seeing right now is a subscription version of this, but tonight we actually have attendance numbers that mean that we wouldn't need a subscription version of this. You can have up to 30 responses for free. So you could do this activity with your students using Poll Everywhere. There's a bunch of different types of questions out there, multiple choice, word cloud. This obviously is ranking. All right, let's see what some people are saying. Again, we've got Tinker at the top of the list. Glad that we're doing applying precedents next. I think the next argument is really fascinating as a former teacher, and I would imagine that anyone, all of you as teachers, and certainly any school administrator may be pretty freaked out at the ideas that are in the second top ranked argument that the school shouldn't have authority over Snapchats posted on a Saturday off campus for a school sponsored activity sent from a personal phone. So that would be a lot to manage. And somebody asked a question in the Q&A. I don't think it got answered about whether, it was Emily's question. It's at the very top. Would a court ruling saying schools can take action create the expectation that schools do so? That's a good question, and certainly a challenging question to think about. All right, so now I'm going to turn it back over to Kathy, who is going to talk about applying precedents.
Okay, so we're going to do a little modification of the applying precedents activity, but this is an activity that we really like because it takes cases that are in standards, or in this case, a case that is also in the one of the 15 AP government and politics required cases, and have the students apply them to something that's happening recently or in real time, like the Mahanoy v. BL case. And for those of you who do teach AP, this is a great scaffolding activity for FRQ3, the SCOTUS comparison FRQ. That doesn't mean you can't do it if you're not in an AP class, but it is a great activity to scaffold for that type of writing if you are. So we're going to sort of chop this activity in two parts. The first part is to look at our comparison case, Mahanoy v. BL. And if you were doing this with your students, you'd want to give them the case summary that Jen talked about earlier. After there's a decision, you'd want to take off the decision. But right now there isn't one, so you don't have to worry about that. This case is being argued, by the way, we didn't mention, on April 28th. So it will likely be one of the very last decisions this term, probably mid-June. And so you'd give them the case summary except for the decision. And then if they're not already really familiar with the precedent case, you'd also want to give them the case summary, or at least a synopsis of the Tinker case. We feel like you all probably were familiar with them both before you came today. If you weren't, you are now. So we're not going to give you anything. But I think, Mr. Korn-Revere talked a lot about Tinker and what that case precedence was, and we've walked you through the facts of Mahanoy. So the first two things we're going to ask you to do is think about how these cases are analogous or similar. What do they have in common? And then how these cases are distinguished or different. And if you're not comfortable with the terms analogous and distinguished, and those are terms that you think you don't need to introduce to your students, the applying precedents activities are all downloadable as Word files too. So you can just get rid of those words if you just want to say, how are they similar and how are they different? So tonight we're going to use Jamboards. I don't know if you're familiar with Jamboards or not, but Jen and I really love them at the moment. And we're going to send you out to Jamboards based on your last name. So we're going to send A through H to Jamboard 1, I through Q to Jamboard 2, and R through Z to Jamboard 3. And how Jamboard works, Jen just put up, I'm not a live Jamboard. This is just our flat Jamboard for you. But we're gonna drop a link in a second, and it's gonna take you to a Jamboard that looks exactly like this. It's gonna take everybody to the first Jamboard that says Jamboard 1, last name A through H. So if you are not in that first Jamboard, you're gonna need to toggle using the little toggle at the top, as Jen is doing right now. And all of them are going to set up like this. How are the cases similar and how are they different? So you're going to make green sticky notes with everything about how they're similar. So, you know, they both happen in public schools, and I won't give you any other ones. And then you're going to use, you're going to change the color on the sticky and make it pink for how it's different. The way you make the sticky is the fourth icon down on that icon bar on the left is the little icon to make your sticky notes. And you're gonna have, you know, about 10 other people in this room with you. And so there could be all sorts of sticky notes coming up. The only little kind of glitch sometimes with Jamboard is that sometimes it will put the sticky notes right on top of each other. So if you notice that yours got covered up or that yours covered somebody else's up, you can drag and drop them anywhere you want. Okay, so we're gonna give you, Jen, how much time do we have to work on the Jamboard?
We've got plenty of time.
Okay, so we're gonna send you out to the Jamboards, and then we'll give you just sort of a little heads up when it's almost time to close. You can see people are starting to populate this first Jamboard. And, you know, we're not going to check your last name. So if a Jamboard is really crowded, you can go to another Jamboard and work your magic there. So we're just going to give you some time to do that.
Alternately, if you feel like you're alone in the Jamboard, you can go to one that's busy as well.
There you go.
Kevin has jokes for us. Thanks, Kevin. Kevin is also demonstrating one of the dangers of using Jamboard.
It looks like it's slowing down a little bit, so we'll give you a few more moments. last call for any stickies anyone wants to make before we take a look at what people wrote here. And you can feel free to toggle and see what's on the other boards as well. And while you did that, I put in, I just dropped the link for the Mahanoy Applying Precedence activity. So at the end, we're going to tell you where you can find all of these activities in like one easy location. But in case you want to pull that up and look to see what it looks like, you could do that. Okay, so how are they similar? We see some things about, they both raise questions as to how disruptive the speech really was. Yeah, that definitely was a question in Tinker. No fights broke out that day. Nobody walked out. As the disruption, as you heard Bob say earlier in the Mahanoy case, will definitely be a big part of what both sides write about. And so that will, that will be a big part of it. There was a great quote in one of the briefs. I read them all in rapid succession, so I'm not gonna ascribe it to one or the other, but about how there is always social media drama with cheerleaders on the team. And so there was some drama, cheerleader drama about this, but that wasn't atypical for that team and that group of girls. So yeah, that's a great point. I'm just going to pull one from each one on each of them. As far as how are they distinguished on this first board, BL used profanity and Tinker didn't. I think some of it will come down to that symbolic speech. One was symbolic, this is sort of touches on a lot of these. One was symbolic speech and one was actual speech. And it was speech that, I think is a blanket word that is not considered acceptable use in school. So there's sort of no debate about that. Jen, do you want to go to the next board? Another one for how they're analogous. The ACLU paid for appeals costs. I think that's true. That wasn't in the brief, so that's a little outside knowledge. Yeah, but for a lot of these student speech cases, the people involved in these cases don't have the kind of resources to be able to bring a case to the Supreme Court. Yeah, and the other one said free speech at school, and yeah, and more importantly, free speech at public school. As the last question that I snuck in there under the wire, this really does have to be in a public school for it to be a case that that the court would take. And students suspended based on the actions. One was suspended from academics, the other one was suspended from an athletic activity. So that's a great example of how some things can fall both under how they're analogous and how they're distinguished. So they were both suspended, but one was not. As far as the differences on that one, oh, whoops, can we go back to the differences on that one real quick? Yeah, so at school and not at school, that is going to be a big part of it. And as came out in the questions, where that line is, and now certainly with so much of learning being remote or hybrid, it really blurs that line. A friend of ours sent us a video today of his students mooting this case in the classroom, and some students were live in the classroom and some students were arguing remotely from their devices. So, that's a great example. Okay, last one. Good. Both were expressing an opinion. True. One was political. One was more personal, but definitely both making an expression. And the other one, and the one on the distinguished, social media versus symbols. Yeah, I think the uniqueness of social media and the sort of omnipresent part of social media is going to be a big part of this case. Okay, can we go back to the PowerPoint? So before we move on, I did want to show you that if you download the materials, you'll also be able to go to an answer key. So these were just some things that we generated on the answer key about ways that they're similar and ways that they're distinguished. And if you look at, sorry, I meant to bring this to our attention before we moved out, but if you look at the Jamboard itself, you'll see that there are slightly more sticky notes in the distinguished column than in the analogous column. And these are pretty much the ones that you brought up. So you brought up all of these, I think. I don't know that there's any on here that, that weren't somewhere on that Jamboard. Okay, let's go to the next part. So the second part of this activity is once students have decided how they're analogous and how they're distinguished, and they've brainstormed in their groups or using Jamboards or in their breakout rooms or however you want to make it happen, how the cases are similar and how they're different, then they figure out what that means for this case that hasn't been decided yet. So, so we're going to ask you to do this in a moment as well. We're going to ask you to think about overall then, is Tinker more analogous to Mahanoy or distinguished from it? So think about not just the number of ways they're similar or different, but think about that ranking activity we did before. And of the ones that you feel are really important, are they more alike or are they more different? So of course, in Tinker, they found for the students and protected students' speech rights.
So when in doubt.
So, so that might mean that you're going to find in the last question for the student. So once you figure out if the case is more similar or different, that should compel the decision in the case, because in theory, the Supreme Court uses stare decisis or stare decisis, depending on how you want to pronounce it, all those Latin terms, which means let the decision stand, and that they should decide this case based on Tinker. So we're going to ask you, are these cases more analogous or distinguished? And then based on that, how should Mahanoy be decided? Should it be decided for the school district or should it be decided for BL? So Ben, can you launch the poll, please? There it is. So you should see a poll now. And if you would just take the poll, we'll give you a few minutes to think about that. And you'll notice that we made the question, how should the case be decided, not how will it be decided. As Jen mentioned before, I think both questions are interesting, but they're not the same question for sure. So, so today we're asking you, how should it be decided? If you want to put in chat how you think it will be decided, that's an interesting discussion as well. Okay, we'll give you a couple more seconds to register your decision, and then we'll ask Ben to show us the results. Okay, Ben, do you want to show us the results of this poll? Okay, so more people thought it was distinguished, and so it's kind of interesting then that that people think that it should be decided for BL, since that would be really the same result. But like I said, it really depends on where you find the arguments the most compelling. So I mentioned before that we would tell you sort of the one-stop shop for all of these resources on Mahanoy. There are also resources there for two other cases, Torres v. Madrid. that was argued in October. And I've been saying it Caniglia v. Strom, but I listened to oral arguments today because this case was just argued today and I've been saying it incorrectly. But these three cases all have resources on our page on our website called SCOTUS in the Classroom. And every term we pick the most teachable cases. So these are cases that are accessible to students. They have fact patterns that the students will understand and find interesting. We try not to pick cases that have weird, wonky legal things happening like mootness. Every once in a while, we miss that. Last year, we picked a case, New York State Rifle and Pistol Association, which got mooted. But we try to avoid cases that seem to have the potential for that. We try to pick cases that you could comfortably moot in your classroom. Not every case is good to moot. Some cases are really sensitive and you wouldn't want to put your students in the position of having to argue for one side of a case or both sides of a case. So we try to pick these cases that we can say to you pretty comfortably, like this we think would be a successful moot in your class. And so this is where you can find all of these materials for Mahanoy. We have, for this case, because we knew it was going to be a really high interest case, and we know that a lot of middle schools teach Tinker. We don't always do the materials at middle school just because it's, you know, it's time consuming to do everything for that. But when we think there's a need, when we think there's a demand, we do. So you can reach out to us with that if you have one. Both the case summaries are done at high school level and middle school level. We've done classifying arguments activities at both levels. This applying precedent activity that we did today, but in, you know, worksheet form that you could hand out to your classes or disperse through whatever your learning management system is if you're online. We've done a deliberation, and I'm going to let Jen talk a little bit about that when I'm done talking about the other things. We will link to the briefs. As I mentioned, the respondent's brief has just been filed today. Once oral arguments happens, we'll have a link there so you can go straight to here and have your students listen. The opinions will be linked when they happen. And we usually try to pick a couple articles that we think are helpful to you. Sometimes these are student friendly. Sometimes they're more to build your background. Like the Education Week one is probably more something that you would want to read for your own background. Okay, I'm going to let Jen talk about the deliberation.
Yeah, so one of the strategies that we like to use at Street Law, we call a deliberation. It's based off of structured academic controversy, but often these current Supreme Court cases can work really well if you choose to, instead of mooting the case, instead of simulating the Supreme Court arguments, you could just choose to have students have the conversation and examine the arguments on both sides and also see if there's common ground. That's sort of what the deliberation is about. It's a big difference between the deliberation and the moot court, is asking students to think about what are the best arguments on either side. Now that we know the best arguments on either side, what do we personally think about the arguments and what personal opinions do we have about them? And then what common ground can these two sides find? And hopefully it's policy common ground. So I'm going to put in the chat the link to, if you're unfamiliar with Street Law's deliberation methodology, we have a resource bundle and a video that shares a little bit more about how that methodology works. So now we wanted to save some time to hear from you all about your thoughts on how you would adapt the activities that we just did for your own classroom. And I know that we have at least one or two people on this webinar who've actually taught this case already. So if you've taught this case already, I think we're definitely interested to hear your thoughts on how it went and what you did to make it successful, or what you would have done to make it successful. So if you want to put any of your thoughts on this question into the chat, just make sure that you click all panelists and attendees so that everyone who's attending can also read your response. So, Mary, we'd love to hear how the moot court goes with your students. So. And Emily, I would definitely love to hear how a SAC went with it as well. Yes, Dan, I got a chance to watch that clip and it was really cool. I thought it was great how you were able to do that as a hybrid activity. I'm wondering if you might be able to expand upon how you planned out the hybrid activity, because I'm sure there are other teachers in your situation. And we've got Kevin right there who says, I want to know how to do this in hybrid. So definitely would love to hear that. Maybe, Kathy, we can put some sort of guidance for hybrid up on the website as well. Come on, Dan. Yeah, I think, Mary, I think you're not alone in the winging it part of things.
Someone mentioned scaffolding by using our activity that that uses the Kohlmeyer case, Hazelwood v. Kohlmeyer, Tinker as the precedent and Hazelwood v. Kohlmeyer as the comparison case. So I dropped the link to landmarkcases.org. Tinker is on landmarkcases.org, so there are lots of resources there, and then that have all sorts of activities, including that one in Hazelwood v. Kohlmeyer is also on there. So you can find that activity both of those places.
And Dan mentioned having a live watch party on the 28th when the case is being argued. So one of the benefits of our current situation is that the cases are argued live and you can listen into them. So if you do moot the case prior to the 28th, that's a great activity to set up for the 28th.
To Ryan, who says he wants to moot it, but probably doesn't have time before the AP exam. For sure, this case is not going to be decided till one of the very last cases. So your students would have access to the oral arguments, but they're not going to have access to the decision for sure. I think that the AP exam is May 3rd or something like that, right? Very early May. So there'll be plenty of time to moot it afterwards without a decision. Yeah, so somebody also mentioned not giving the students the arguments before they moot. We've definitely done, when we work with teachers, if we're live and we have a lot of time, we definitely make the teachers come up with their own arguments. But if you are pressed for time, or you know, the situation that you're teaching at the moment isn't really conducive to that, supplying the arguments is a good way to have them still have to rank them and still have to put them together and still have to really sort of internalize them, but not have to create them themselves.
Yeah, OIA offers the recordings of the cases once they're argued. In fact, you can find the arguments from decades ago. You can find the Tinker oral arguments on OIA if you wanted to.
Yeah, and the beauty of the OEA ones, as opposed to like the C-SPAN ones, are that they will, not in real time, but very shortly afterwards, have the text pop up. So you see the justices, and they, you know, they get bolded when they're speaking. So the students can see the person who's speaking and read the text. And if you listen on your phone, like what I do a lot is I screenshot it, and then I have that captured of where in the argument, when they say something, like when they start to talk about Tinker, and I get all excited because you want to show your students how they applied Tinker, you can screenshot it and then find it easily. Yeah, someone said no video in the court, and the justices have really put their foot down about also not Zoom calling, you know, because I think for a while people were thinking that you would see like the Brady Bunch, 9 of them in a Zoom call. That is not happening. So it's telephonic.
Someone mentioned earlier doing mini moots in hybrid, and we have, I'll find it later if I can. Okay, thanks, Kathy. We have a video of how you could do mini moots online. I'm sorry, no, in person. But we've been doing PDs over the past several months with moots online, and maybe easier to manage in that case. Just putting students in groups of 3 where one is representing Mahanoy, one is representing BL, and one is a justice. Oh, that's a good idea, Mary, to imitate the way that the justices are working right now. Each justice gets a certain number of minutes instead of being able to interrupt one another, which I think one thing maybe I've learned from all of this online interaction is that it's even more awkward to interrupt people online than it is when you're in person. It's not any better, but maybe regulating the justices' time in the way that they work. No interrupting in hybrid. Yeah, I would make it pretty challenging.
Yeah, and Ryan mentioned the dogs in robes. You can find those if you search for them. Students love them, although it's a little distracting. They are super cute. But someone with a lot of time on their hands creates those.
Are we ready to, you want to move on? So I guess we'll pause here for just a moment. We don't have any questions in the Q&A, but if anyone had any questions about teaching the Mahanoy case, thus far we've just kind of shared our own strategies, but if you have any questions for us or for your colleagues, go ahead and put those in the chat and we can kind of get a conversation around any questions that you might have about teaching the case. Yeah, Kevin, we were like crossing our fingers and our toes in the hopes that the Supreme Court would pick up this case, just because we knew it would make it's sort of like one of those once in a decade kind of good cases for students to work with in their classes. All right. Well, if you have any questions, you can there's still time to add them in the chat. We're also going to put our emails up there pretty soon, but let's go ahead and wrap things up. So our objectives, hopefully you feel like we met the objectives, and we are in next week, we're going to offer our student webinar. Bob is going to join us again. If your students have already done this case, have already learned about this case, it's a great opportunity for them to dig in a little bit more with Bob. And wanted to share with you some of the stuff that we have available to you, just in case you haven't heard from us in a while. So there's lots of free materials available on our Street Law website. We've dropped links throughout for case summaries and instructional videos and deliberations. When you access our materials, we call it a store, and everything that you access will be free. So make sure when you get to the very end, you'll see that payment is not required, but some people freak out because they do see that word payment and billing, but don't worry about that at all. It will be free. Our student series can be accessed at the long link that Kathy just put in there.
I was confident it was the right link, but now I'm not. So I will go look again for a link.
But next week's student webinar will just be an hour long. It will be basically the first half of today's webinar, where we'll go over the facts of the case. Bob will talk a bit about applying the precedents, and then there's going to be a lot of time reserved for Bob to do Q&A, and we'll have a student facilitator for that one.
Okay, I'm going to drop a better link right now.
Okay, and the better link is coming. And then Kathy is going to talk very quickly about this update about the Supreme Court Summer Institute.
Yeah, so if you were with us last week, or 2 weeks ago, I mentioned that we did decide that this would be virtual, that the Supreme Court Summer Institute would be virtual this year. So this year it will be a 5-day deep dive into the Supreme Court and some cases, this one included, but other current cases as well. We'll have lots of visiting or experts who will come in to talk to us about all sorts of different aspects of the Supreme Court. We'll cover topics like granting cert, why the Supreme Court takes the cases it takes and how it goes about that process. We'll talk about nomination and confirmations. We'll talk about judicial philosophy, all sorts of things with leading scholars. So the big difference this year is that it will be virtual, which is not ideal, but it actually might make it so that some people who couldn't travel to DC can now attend. It will be from 1 to 5 each day Eastern time. And to show our appreciation for people coming virtually after a long year of teaching and maybe having a little Zoom fatigue, this year we're going to waive the $150 registration fee, and we're going to have a modest stipend of $200 for all teachers who complete all of the required sessions and submit feedback forms. So, so it's a competitive process, but if you'd like to apply, please do. If you have questions, please reach out to me. So we have 1 more week of applications. And if you decide to apply and can't quite get a letter of support together in that week, please just reach out to us, because we know that sometimes those things are a little out of your control. So yeah, please reach out to me at cruffing@streetlaw.org if you have any questions about the Summer Institute or how things are going to be different this year because it's virtual.